Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3064, United States of America versus Antonio Malachi Bryant, appellant. Ms. Rowland for the appellant, Ms. Kalu for the appellee.
Good morning, Ms. Rowland. We'll hear from you.
Good morning. Sandra Rowland on behalf of Antonio Bryant. When you know that you are the target of police action because they've made a brisk beeline to you and you alone, because they've questioned you and you alone about a gun, the additional knowledge that you have been deliberately surrounded, not by happenstance, not accidentally, but deliberately, makes it perfectly clear that you won't be allowed to walk away. There was no reason for Officer Smith to go around the back of the SUV except to surround Mr. Bryant and to communicate to him that he would not be allowed to leave. He testified that that was the very point of doing that it was a tactic, and that it was a tactic that they use to prevent people or give people the impression that they are not allowed to leave.
Did he say that, or did he say he did it in case he ran, to keep him from running? I thought his testimony was that he did it to keep him from running.
He didn't testify that it was in case of running, but he testified that he did it. He said, I don't want him to run. So I don't want him to run is the equivalent of I don't want him to leave, whether it's running or walking away. You can't simply surround people, communicate to them that they can't run without also communicating to them that they can't walk away. So it's the same here. They didn't want him to run. They didn't want him to leave. And he didn't, because he understood what it meant when they targeted him and then surrounded him.
Well, so far, where is the unconstitutional police conduct?
The unconstitutional police conduct is in making a show of authority to which Mr. Bryant submitted without reasonable particularized suspicion that he was.
I understand that, counsel, but the facts that you were discussing both before and during the question by Judge Wilkins, I'm looking for the unconstitutional conduct.
The unconstitutional conduct is surrounding him on both sides, basically blocking his or partially blocking his two avenues of egress, thereby communicating.
Let me just be clear. That's what I want to understand. Is it your position that under Terry, a police officer cannot approach me from the front and the back?
It's not our position that a police officer cannot do that, but if they do that, that is a show of authority, and that's okay if they have reasonable suspicion. But if they don't, it's a violation of the person's Fourth Amendment rights.
No, I understand that argument.
I'm sorry, I'm not getting what you.
Well, I see a police officer coming in front of me and heading toward me, and I've just seen another officer behind me.
Well, I think that any reasonable person who sees officers coming toward him at a brisk pace, coming toward him alone, where one comes in front of him and the other one detours out of his way to come behind him, and then asks him whether he has a gun, so letting him know he is targeted, and he is targeted in a very serious matter. That no reasonable person would think They could just say, "Excuse me, officer," and glide past.
So if I'm walking down the sidewalk, or if a person is walking down the sidewalk and a police officer is walking towards them on the sidewalk, it would be unreasonable for them to feel like they could just walk past the police officer on the sidewalk?
Well, we don't have that circumstance because
I'm
He
not
was
asking
blocked
what
on
was in
both
this case. I'm just saying in general.
in
In
general,
general, a citizen, if they see a police officer walking towards them on the sidewalk, should feel like they cannot walk past the police officer?
no, that is not what we're arguing. And that would be the natural course of things. An
Okay,
officer
so
is
that's what I'm
walking.
trying to get at. What are you arguing? If it's not what Judge Wilkins just asked you.
It is not a violation of the Fourth Amendment for a police officer to approach any person. And if they happen to be coming toward that person, it's perfectly natural that, they would direct their question to that person in front of them. But when you make a detour to go around so you can surround the person, so they can't go forward and they can't go backward without encountering you.
Well, the
That
district
is very
court,
different.
found that there was 8 to 10 feet. I mean, I'm suggesting by my question, I think, that you're arguing a more difficult case than you need to.
But is it clear that you're indicating the seizure is when you have Officer, is it Benitez?
Benitez, yes.
Benitez, at least how it presents on the video body cam, that Mr. Bryant can see Officer Benitez on his right. Then Officer Smith is going around the car, and then he's on Mr. Bryant's left. There's a vehicle, which is the white SUV in front of Mr. Bryant, the gate behind him, and then yes, there's trash cans, but Mr. Bryant didn't in effect close himself in. If he walked either way, he would go to an officer. So the officer's intention at least looks or appears to be that he's surrounded, and then that's your seizure?
Yes. Defense counsel below identified the seizure at the moment that he was surrounded,
Right.
but also later at the moment that he was surrounded and questioned. So at either of those points, and we've argued in our brief that it was at the moment that he's rounded the corner and questioned Mr. Bryant.
So
We don't need it to be any earlier.
So I think the challenge that I'm having with your position, just to be candid and cut the brass tacks here, because I want you to give me your best answer, is that I think that the district court found that Officer Smith rounded the SUV at 19 hours, 40 minutes, and 0 seconds. And that's what the body camera footage appears to show. In that Officer Smith asks the question, "What's that bulge?" 3 seconds later at 19 hours, 40 minutes, and 3 seconds. In that Officer Smith, in that 3-second interim, is also raising, I think it's his left hand, and pointing towards Bryant's waistband, indicating that he sees something there. And obviously he would have seen something before he verbalizes the question, what is that bulge there? So the district court finds that somewhere between the 0-second mark and the 3-second mark, Smith sees a bulge. That's also basically pretty much concurrent when Smith is stepping up onto the sidewalk and when the seizure happens. So if we were to find that upon seeing the bulge, there's reasonable articulable suspicion, then the government says you lose, and the district court says that's why you lose your motion. So what's wrong with that way of looking at this case?
If the court is kind of identifying the short time period as, problematic for my argument, I disagree with that. And human perception is lightning fast. And when he rounded the corner, or even when Mr. Bryant could see him coming around, he was seized then. He was seized the minute he came around the corner, and then he spoke. And he didn't say right away, "What's that bulge?" He didn't see a bulge. He asked a couple of questions before that. "Do you have a gun? And did you step off? Did you walk away from the police?" So at that moment, even if it's 1 second away from the moment when the officer perceives, thinks he sees a bulge, that isn't really relevant. These things happen very quickly. In the days before body-worn cameras, it all seemed like it took minutes. But now that we have body-worn camera, we know that it doesn't.
But on your position, we need to find a seizure, right, when Officer Smith comes around, and then the rest flows.
And speaks the words, "You don't have any guns, do you?" Yes.
So the
that is
movement
the
of the
seizure.
officer and the question.
Right. So that is the moment of seizure. And
So
what
your argument is that looking at the totality of circumstances, you have two officers moving briskly toward one person, passing by others, and they're closing in on him. And the district court was focusing, as I read the record, on the fact that, among other things, the officers were in the time scenario that Judge Wilkins just surveyed with you. Things were moving quickly. And the Supreme Court has often emphasized the need for the police to move quickly. And the government, I assume, will focus on the fact, well, it was 8 to 10 feet. Between the two officers. And it's Judge Wilkins' focus on the fact that everything was moving so quickly that at the point the officer asked, "Do you have any guns on you?" And the defendant says no. And at that point he seized?
Yes, at that point he's seized. Mr. Bryant did nothing to put any time pressure on this. That was all about the police conduct. It took them 23 seconds to get out of the car and get to him. The fact that they were moving that fast, the fact that they decided to surround him instead of do what's more natural, which is approach him from the front, is all police conduct. It has nothing to do with what Mr. Bryant has done. And it creates the impression in any reasonable person, I think, that they would not be permitted to just avoid all of this and leave.
So just so that I'm clear, I think that the defense counsel below said the seizure occurred once Officer Smith blocked egress on the sidewalk.
I'm sorry, when he what?
When Officer Smith blocked arguably egress on the sidewalk.
Right.
Are you arguing now that seizure occurred prior to that moment?
No, I'm arguing that, as the defense counsel did below, that when Officer Smith rounded that corner and said, "You don't have any guns, do you?" That was the moment of seizure. That was the moment that he knew he was targeted in a very serious investigation and that he was surrounded. The only way, well, I won't say that, the way that the district court avoided concluding that he had been seized, that there was a show of authority, was by finding that he didn't know he was surrounded, that he didn't know Officer Benitez was in front of him. But the video evidence shows otherwise, particularly if you look at minute 39, 52 seconds, up through 59 seconds. You see that he did, his body, his feet, his face were looking straight at Officer Benitez.
So based on your argument that the district court clearly erred in that regard, this court would owe no deference to the district court's legal conclusion?
That is correct. The legal conclusion that there was no show of authority.
Well, I really meant to
based
frame that.
on-
Counsel, I may have misled you by my question. I meant no, that the legal question is de novo before us, but that in resolving that, we owe no deference, as we are told, to the historical finding by the district court, because that was clearly erroneous.
Yes, that is correct. That was a clearly erroneous finding, and that really is the basis for the district court's finding that there was no show of authority, because he didn't understand that he had been surrounded. But he did understand that.
See, what I'm getting at is a hypothetical situation. And I know my colleagues will respond, but the police have a problem in this city, high crime area, lots of guns. All the regulation of guns are being struck down as unconstitutional. So what's a community to do? So very much like the 60s, they have this basic jump out methodology. And it's been made more sophisticated by instructing the officers not to ask certain questions, not to do certain things, because then they will be violating the Constitution. And what I'm trying to understand in my own mind from your perspective, if you're not going to focus on that clear error of law, then the fact that I see exactly what Bryant saw means he was seized. I'm trying to think of a scenario where we're supposed to view the facts based on the evidence viewed most favorably to the government. And so hypothetically, you could see a scenario where the police do exactly what happened here. And they get to Bryant and they say, you know, do you have any guns? He says, no. He says, well, we're looking for this guy, you know, who had a gun. And he was wearing the same kind of pants you're wearing. Do you know where that guy is? And Bryant hypothetically might say, he ran down that way. And the officers go down that way. So we don't have those facts here. I understand that. But I'm just trying to understand at what point there was an illegal seizure.
Okay.
And you're saying the accusatory question, you don't have any guns, do you? And Bryant says no. And it's a fast-moving investigation. And you can see how this is going to be argued. That's why I'm trying to nail down clearly at what point the unconstitutional conduct occurs.
Okay. Well, the court, of course, is looking at the totality of the circumstances. The totality of the circumstances are that these officers double park their car in the driveway, get out very quickly make a beeline to one person, bypassing everyone else with friendly greetings. Then instead of doing what's natural, which is both going to the person, one officer takes a detour for the purpose, for the obvious person, obvious to any reasonable person, of surrounding him. A tactic designed to prevent people from leaving, and then communicates, you are the target of a serious criminal investigation. That is the moment of seizure, given all of those circumstances. I think that this is a case where it's really helpful to try to, do a little thought experiment. Imagine yourself in that circumstance. If you saw the police coming toward you, very quickly, a beeline to you, ignoring everybody else except to wave hello, and then do something extraordinary to surround you, to corral you, and then ask you a question about a very serious matter, gun possession, would you think you could say, excuse me, and slide on past? I don't think any reasonable person would think that. And I'm sorry.
So did Officer Smith, at the moment that Officer Smith observes a bulge, which the district court credits, do you agree that he had reasonable articulable suspicion at that time?
I think that the Officer Smith's testimony is, quite shaky about what he saw and when he saw it. But yes, if he saw a bulge in his pants and it looked like what Officer Smith has seen in the past to be a gun bulge, then yes, he has a reasonable articulable suspicion.
So the district court finds, this is at Joint Appendix 168, that Officer Smith steps onto the sidewalk at 19:40 and 0 seconds. And then it's at 19, and then basically in the 3 seconds, what happens are, he says, you don't got any guns on you, do you? Bryant says, nah. Officer Smith says, stepped off. Doesn't really get a response to that. And then immediately says, what's that? What's that bulge right there, bro? And then that is happening at 3 seconds later. So in the 3 seconds, all of those things happen.
Yes.
So your argument is that he was seized at 1940, and it's unconstitutional because at that moment, he didn't have reasonable articulable suspicion. He got it somewhere maybe 2 or 3 seconds later, and so that violates the Fourth Amendment, and we should suppress the gun.
Exactly. And that really is not an extraordinary proposition to say that 1 second you don't have reasonable suspicion and the next second you do. I mean, that's how
So because he was
perception works.
seized unconstitutionally for 2 seconds, maybe
Well,
3 at the most,
If
could have only been 1 second because he could have seen the bulge at 1 second. So he was seized unconstitutionally for 1 second, so we suppressed the gun.
Absolutely. If he had not been seized, he could have turned away and walked off, and there would be no bulge to be seen. I mean,
What if he has to walk around the car to that side so that he can see his waistband? Because for your own safety, you don't want to be, to the back of someone who might have a gun in their waistband who can reach and grab it and turn around and shoot you. So you have to, for tactical purposes, come around so that you can see the front of them. And then also, if they start running, you're in a position to grab them.
well, there was
Police are
someone
in
in
the business of catching people, not letting them run away from them, right? right?
There was someone in front of him, Officer Benitez, who apparently did not perceive a bulge. There's no testimony about that. And, you know, which direction Mr. Bryant might have gone in, forward, backward, we don't know because that didn't happen. But
The testimony
He
was that Bryant was walking away from their direction and was kind of blading his body, positioning his body in a way that also raised suspicions of the officers, right? So why wouldn't the officer want to walk around to the other side to get a better view? These are life and death. The officer wants to go home at the end of the shift, just like, you know, you and I do, right?
Officer Smith testified that the reason he went around was to communicate that Mr. Bryant should not leave. He didn't go around there, or he didn't explain any tactical reasons other than that, like for safety or anything. He absolutely had the opportunity.
I mean, that's your
And he
gloss.
didn't say that.
He says, I didn't want him to run.
Right? That's not a gloss, that's his testimony.
Yeah, I mean, I can say I don't want you to leave. That doesn't mean that I'm, you know, I love having this interchange with you. That doesn't mean that I'm ordering you to stay, or, you know, you could say that.
You're not an armed and uniformed police officer. If an armed and uniformed police, two of them, surround a person and say, I don't want you to leave, I think the court would interpret that as a seizure.
But I mean, he didn't say any of that. He's just saying in his mind, I didn't want him to run.
And he communicated that.
At what point did he tell Bryant, halt?
Well, he never said the words halt. He surrounded him, he asked questions, and then he allegedly saw a bulge and, you know, moved in to handcuff him. But certainly the word halt is not required for a show of authority. And in this court's cases, in Delaney and other cases, it was never required that the police say halt. You know, what was required in Delaney was that they partially blocked his ability to leave, and they came around both sides of him. There were other factors. There's a top light, but basically that was it. They didn't, an officer's not, suppression is not only required when an officer says you can't leave or halt.
Let's talk about earlier, there was comments by the government in their brief. You're in the high crime area, you're passing people, it's night, you're going to this particular street where you see, you know, observe some people, and that they are indicating that Mr. Bryant looks around, hears the word 12, which is supposedly, you know, alert police spy, pulls up his waist, you know, just all of those observations. Before the government comes up, I just want to give you an opportunity to answer that, because as I listen to Judge Wilkins' questions a little bit about what's wrong with an officer feeling safety and, you know, that line of questioning. What would you say to that part that occurs before Officer Smith walks around?
Okay, thank you. I'd like to address both Mr. Bryant's conduct and the character of the neighborhood. So Officer Smith testified that he thought walking from one vehicle to the next when the police came up the driveway in an unmarked car, looking over his shoulder in the direction of the officers in their unmarked car, and touching his waist or his genital to be a security check. He interpreted it as a security check, and he interpreted all of those things as suspicious because he had heard the word 12. And he says that directly at page 126. It was because someone had shouted 12, and he heard that he interpreted everything Mr. Bryant did, all of which were quite innocent, as in response to the police, and therefore suspicious. There's absolutely no evidence that Mr. Bryant heard or understood the term 12. And I refer this court to Castle, where the court said there has to be some evidence, some direct evidence that the person knew of the police presence. And it's not enough to say, or it just sort of doesn't work to make a circular argument that, well, we know he knew it was a police presence because he did these things, and these things are suspicious because he knew the police presence. There has to be some evidence that he knew.
Why isn't the fact that as somebody is saying 12 and the car is coming up, he turns and walks away? Why isn't that circumstantial evidence that he knew that there was police and he wanted to, avoid the police by walking away?
Well, Mr.
Maybe trying to
Mr.
hide his presence behind the SUV.
He didn't walk very far, did he? He walked a very short distance from one car to another. And at that moment in that apartment complex, and you'll see in the videos, there are people moving around. And they aren't all moving around because they're not frozen until the police come up. And the only way to conclude that those are suspicious actions is if he knew. And there's no evidence. He didn't shout police. They're in an unmarked car. No one there's just no evidence that he knows that that unmarked car is the police, and that
Well, they're in police
his conduct
uniform.
that follows is
They're
because
in
of
uniform, right?
Pardon me?
They're in police uniform.
They are, but they're also seated in a car. And when you look at Officer Smith's testimony that his body-worn camera that he's wearing on his chest doesn't capture things beyond the dashboard, well, it also goes both ways, looking into the car.
So I want to be clear, because your own brief at page 12 quotes Officer Smith as saying, Bryant answered the question whether he had guns on him, saying no. 2 seconds later, Smith asked, stepped off. Then, what's that bulge right there, bro? Hold right there. That's in quotes in your own brief.
Yes.
All right. So I thought, and let's ignore for the moment the clear error about whether Bryant had seen Benitez. I thought the district court was with you on the first phase when the officer was coming around the white SUV. And then, because she says, the closer question is, what was the situation when Bryant started asking questions? And I thought that was, maybe I misunderstood what Judge Wilkins was getting at earlier, that given the shortness of time here, all of this is almost simultaneous. He's coming around the car. Do you have any guns? Step off. I didn't know what that meant at all. And
It
then
means, did you walk away?
Well, I thought the testimony was Bryant indicated he didn't know what it meant either. But in any event, this is all very quick. This whole scenario is happening within 7 seconds. All right, and just count 7 seconds and how fast that is. So trying to slice and dice each thing to stretch it out isn't portraying what the transcript shows. And I thought that was the thrust of some of Judge Wilkins' questions. And you're resisting that. I'm not sure why, but in any event.
I guess my point is, however many seconds, and it was 7, there was time for Officer Smith to get around the corner to say, you don't have any guns, do you? And then say, receive an answer, and then say stepped off. And those things do happen quickly, but they don't happen simultaneously. And the court is going to have to do this with these body-worn cameras in every case, right? Or at least quite frequently. There's a moment between, not perceiving and perceiving. And in that moment where Officer Smith came around the corner and started asking him questions, he had not perceived a bulge, but there was plenty of time for Mr. Bryant to perceive that he wasn't getting out of this. He wasn't going to be able to walk away from this. And, in that split second, he could have said, excuse me, I'm leaving. But for the fact that he understood that that was not going to be allowed. I think there might have been a second part to your question. I'm not sure. But if I could get back
I'd like
to
to
Judge Childs's.
bring this to a conclusion unless one of my colleagues have
Well,
another question.
if I could answer the second part of Judge Childs's question about the character of the neighborhood. Of course, Officer Smith never said it was a high crime neighborhood. And if the police are going to diminish the constitutional rights of thousands, tens of thousands, maybe hundreds of thousands of people who live in this city in bad neighborhoods, this court should require that they at least nail it down. Smith testified about the area, which he defined as either Lincoln Road or PSA 708, Livingston Road or PSA 708. He did not testify about this quite large apartment complex. He didn't particularize his testimony to where Mr. Bryant was at all. He said that there was an open air drug market in the gas station that was not part of the complex, was a distance away, and was separated from the apartment complex by commercial buildings and shops. He didn't even give specific evidence about this shot spotter. He didn't say when shots were heard. He didn't say where they were heard. He didn't say if there was a shot spotter device in that apartment complex, or was it over at the gas station? Was it somewhere else on Livingston Road or in PSA 708? This vague and insufficient evidence about the character of this apartment complex or the place that Mr. Bryant was really is insufficient to say that the character of the neighborhood contributes to a finding of reasonable suspicion. And, especially so because we already know from this court's cases that it's a contextual factor, but it's a pretty weak factor. And here was no particular evidence about this place. It's really worthless.
Any other questions, Judge Childs, Judge Rogers?
No, thank you.
We'll give you time on rebuttal.
Thank you.
Good morning, Ms. Kalu.
Good morning, and may it please the court and counsel. Jim Namso Kalu on behalf of Applebee's United States. Your honors, we are asking that this court affirm the district court's judgment in this case. The district court did not err in denying Mr. Bryant's motion to suppress evidence. I think it's clear from the questions that have been asked so far this morning that the ultimate issue is when exactly Mr. Bryant was seized in this short, 6 to 7 minute time frame that we have been focused on. In the lead up to that time, those few seconds, we have focused on what happened, but I also would like to point to the court point out to the court what did not happen and what the district court noted in its findings in this case, which was that this horseshoe was a well-populated area. This was not very late at night. This was a well-lit area. The officers did not draw their weapons. Although the court found they were walking briskly, the officers did not run, which is a factor that this court has pointed to in cases like Goddard and Castle. The officers did not physically separate Mr. Bryant from the other individuals in the area. They spoke to him in a conversational tone. They asked that initial question was not, the court found that it was a firm tone, but it was a calmly asked question. The officers were approaching calmly. And they didn't ask, as we've seen in other cases, to frisk Mr. Bryant or to see his waistband. And so I think just from an atmospheric perspective, there are some other factors that the court might take into consideration in considering whether in the lead up to the 6 to 7 seconds that we're concerned about, how much that contributes to whether there is.
So what is your answer to the point of the specific seizure?
Yes. We think the district court is correct that the seizure occurred at the point that Officer Smith asked, what's that there, what's that bulge? So at 40:03.
So you don't see that an officer being on both sides of Mr. Bryant, car in front of him, gate behind him, not leaving him any space to walk one way or the other without running into an officer, or him believing he's confined when you got two officers around you?
And I'm glad that Your Honor asked that question. The district court's findings on that point, which are at JA 168, that's page 111 of the May 21st transcript, are that Mr. Bryant I'm quoting, can be seen turning his head away from Officer Benitez, who was approaching at 19:39:59, and looking toward the back of the white SUV where Officer Smith was beginning to round the corner. And I think this is the key language from the court's finding. At that point, Bryant turned his head to look at Officer Smith. At the point, I apologize. At the point, Bryant turned his head to look at Officer Smith. Officer Benitez was still walking along the road. And I think if the court looks at the body-worn camera, which the district court judge indicated she reviewed several times in conjunction with Officer Smith's credited testimony. She made this finding that Officer Benitez, I would argue, was still in the road. I think that's the point that she was making there, was that perhaps Mr. Bryant knew that the officers were coming in his general direction, as did anybody else on the sidewalk. But what the body-worn camera from both officers shows is that the officers were walking in the street. They were not walking on the sidewalk. It's not as though they were walking up the sidewalk together and then Officer Smith, for example, stepped off the sidewalk and went around the back of the SUV. They both were coming up the street. And so the way that the district court viewed the body-worn camera, at the moment that Officer Smith was coming around the back of the SUV, Officer Benitez, it appeared to the court, was still in the street. And that's what Mr. Bryant would have seen, that he was still in the street, not that he had come up onto the sidewalk to block.
But he's still to his left. You still got two officers on either side. I just wonder how much of a difference of a fact that makes if you still see an officer to your other side, about if you walk that direction, you're walking past an officer. So you don't, would he feel confined that he could not just walk away from that officer?
Well, and I think that this court's case law and from the Supreme Court asks us to consider a reasonable, innocent person, like anybody else who was on the sidewalk. If the officers at that point, they had not spoken to Mr. Bryant, he didn't have reason to think until Officer Smith asked the question specific to him, about what's that bulge there. It didn't have reason to think that the officers were coming to speak to him, as opposed to, there was another man standing at the front of the back, I believe, of a black car that was parked by the SUV. He wouldn't have known until they began speaking to him, asking him specifically about the bulge, whether they were coming to talk to him or to the woman who was standing in the open door of the SUV. And so I do think that while looking at the body-worn camera and listening to, reading a transcript, we do, or rather that this court should bear in mind its the standard of review with respect to this factual finding, that unless the district court clearly erred, unless, in other words,
I feel like you're cabining in whether Benitez was in the street. Should we be looking at this from the perception of Mr. Bryant? Did he reasonably believe he could leave? Because you're telling me from the officer's view of where things stood, but would a reasonable person in that circumstance believe they could just walk past both police officers?
I think based on the factual findings, yes, because the finding is that at the crucial second, when Officer Smith was coming around the back and when Mr. Bryant had begun to turn his head and was still looking away from Officer Benitez, he wasn't on the sidewalk. So the sidewalk, in other words, was still open for him to walk by.
Walk by, but there's a policeman there. That's my question is, do you think you could walk past this police officer if one is coming around surrounding you? Like, would the reasonable person think that they were zoning in on him?
And I think that a person would think that they could walk away. If you have an officer on one side at 8 to 10 feet, was the district court's finding, coming around the one side, and the other officer, according to the finding, has not yet come onto the sidewalk. And what we have instead is the Officer Benitez, has been walking up the road. That's what I understand the district court's finding to be. And at that point, again, it wouldn't be clear. It would become clear some, mere seconds later. But at that point, I don't think that it was clear that he, Mr. Bryant, was the focus of both officers' attention.
So let's suppose the facts were this, that Mr. Bryant didn't stop at the white SUV. He kept walking slowly up the sidewalk. So that when Officer Smith at the 19-hour, 40-minute and 0-second mark, when Officer Smith was stepping onto the sidewalk, Bryant is a little bit past him on the sidewalk because he continued walking. And at that very second, he says, "You stop and turn around." And Bryant stops and turns around. At that moment, is Bryant seized?
I think in that scenario, the officer has given a command, potentially to Mr. Bryant. He's specifically said that to stop and that he wants to talk to him. And so I think that. So
yes, he's seized at that point, right?
Because of the words that have been used.
So at 0 seconds, 1940 and 0 seconds in this hypo, he says, "Stop and turn around." And Bryant does that so that at 3 seconds later, at 1940 and 3 seconds, when Bryant turns around, he says, "What's that bulge?" and recovers a weapon. So he had reasonable suspicion when he sees the bulge, but let's say he didn't at the time he said, "Stop and turn around." We would suppress that gun, wouldn't we? Even though it was only a 3-second long unconstitutional detention. The fact of the matter is that he had been seized unconstitutionally, so we would suppress that gun under our precedent, wouldn't we? This hypo?
On this hypo, if the facts are otherwise the same, aside from the fact that Officer Smith was slightly behind Mr. Bryant. They're the same as this case. We've of course argued that we disagree with the district court's conclusion that the officers did not have reasonable articulable suspicion but before the officer came around the back of the SUV. So if the facts are otherwise the same, I would agree with the court. There's been a seizure by way of a command to stop and a submission to the show of authority, but would disagree that suppression is required. So in other words, Your Honor, I think that the timing is certainly important, but there is a significant difference in terms of the way that encounter, it was a fast encounter in the hypothetical. It is a fast encounter, but I think that it's substantially different.
What's that reasonable articulation?
As
To pin you down, you said, because you said it's before Smith encounter, correct?
Certainly. So again, if the facts in Judge Wilkins' hypo are otherwise the same as the facts of this case, what we have is the officers coming into a high crime area, which I would note, although that is being disputed on appeal, that they're at least in one place at the record, JA 51, which was at one of the pleadings in the district court, it seemed that Mr. Bryant conceded that this was a high crime area. But certainly we would argue that
that alone does not.
putting that, certainly, but would provide context. And certainly according to Officer Smith's testimony is why the officers were patrolling in this particular area. So they're driving up into the horseshoe. They hear somebody call out 12 or someone's call out 12, which they understand to be.
Knowledge whether or not Mr. Bryant actually heard that.
No, but the standard at this point is reasonable articulable suspicion. So far less than preponderance of the evidence.
Right.
Less than probable cause. And so circumstantially, officers could hear that from inside a vehicle that's moving. Presumably somebody standing on the sidewalk would have heard it as well. So
what else?
You have that, and then Officer Smith testifies that Mr. Bryant looks over his shoulder.
And that alone doesn't give you suspicion.
No, certainly.
I'm just trying to think of myself walking down this street as well. Like
Yes.
if I turn my shoulder because I see an officer, I'm gonna do that. But does that mean I've, that we should assume I've committed a crime? If I pull up, straighten up my jacket or do whatever, does that mean that that's enough for the officers to come ask me anything?
I don't think that the officers assumed that he had or committed a crime, but they suspected that they had, because in addition to the factors I've already noted.
Okay, but you've given me high crime area, you've given me looking over my shoulder. I would do that if it wasn't an officer. There's somebody walking down the street and my back's turned to them. And if I just straighten up my clothes, I mean, those are your three facts so far. Is there anything else?
Yes, and as Mr. Bryant begins to walk away, he makes a security adjustment in this officer's training.
And that's what I'm calling the straightening up my clothes. Can I just do that?
I would think, Your Honor, that it would depend. Certainly anybody could move their clothes around or move, objects on their person around. But what makes
there's no bulge seen at that time, correct?
At that time, correct. But what makes Mr. Bryant's conduct at this point notable to the officer is that in his training and experience, that particular movement, that particular adjustment is often associated with checking for, to make sure that a firearm is still there.
I could be looking for my phone that I had in my pocket to make sure it didn't fall out.
Certainly, but the court's precedent does not require that every innocent explanation be dispensed with before an officer have enough to develop reasonable articulable suspicion, at least to walk up and ask a question. Certainly without having seen the bulge, we're not necessarily in territory of putting hands on anybody.
I'm just saying, me walking down the street, I'm in that high crime area, going to the corner store, I turn around because I see somebody, whether it's officer or not, they could be in plain clothes, it could just be anybody. I'm just making sure I check where I am. I'm looking at my surroundings, and then I'm straightening up my clothes because I think my cell phone's about to fall out. Those three things can let an officer approach me.
I think that as Your Honor has described it, I mean, our argument would be that it's a fair inference that Mr. Bryant knew that these were police officers, which is different from just hearing a random person make any sort of statement that would cause a person to turn their head.
Okay, but then you're adding the element that he knew they were police officers. Then wouldn't that institute that there was a show of authority? There was police presence? And so then he thinks that he's confined and he cannot move?
No, not on its own. Otherwise, anytime the police were, just driving down the street or walking down a sidewalk, anybody who perceived the police to be in the area would be seized. And it's not, it's the combination of all of these factors that leads to, we would argue, reasonable suspicion that he was armed.
But I'm describing that as to myself, and I'm just not seeing a distinction that carries over into why is Mr. Bryant different? If I just describe that about myself, those same things, high crime area, looking over shoulder, me adjusting my clothes, why is Mr. Bryant different at this point in time?
And there are the additional factors of somebody has alerted the police to police presence, and he's making it specifically.
They could alert me that the police is there, but it doesn't matter to me. I didn't do anything.
And Your Honor, I would just point the court to, I want to say it's at JA 72 or 73, the first time that, let me double check that, so I'm not telling the court the wrong citation, but when Officer Smith describes that might be the wrong notation. I apologize. One moment, Your Honor. It's a JA 75, where Officer Smith describes the security check, which again, it's not just adjusting clothes. It's a specific movement, and he was cross-examined on this. And he was very forthcoming in telling the district court judge it could have been an adjustment of Mr. Bryant's body. But again, the officers are not required to dispel every innocent explanation for conduct.
I guess
so
counsel, what's striking about this, and Judge Child's question certainly highlighted, and Judge Wilkins has written on this before, so I'm sure you're familiar with what the underlying concern is. I mean, the entire Washington metropolitan region is a high crime area. There are guns all over the place, and the city isn't able to regulate them. So what does the city do? And I was struck how the city is doing basically what it did in the 60s in the war on drugs, but it's trained its officers well, so they don't do some things. And some of the things you mentioned that they didn't do, well, those cases and the officers have been instructed. But the problem, isn't it that, I mean, I thought it was striking. The police knew nothing about this man. They hadn't seen him do anything illegal. It's not like in the war on drugs where they either saw an exchange of drugs or exchange of money. He's just there with other people and their children there. And as Judge Child's hypothetical suggests, you see an officer, you see them moving quickly, you look around. So the argument that the government, I thought, was going to make in part was, look, all those circumstances I've just mentioned, high crime area, can't regulate. What do? The notion of when articulable suspicion arises moves forward, if I can put it that way. In Terry, the men were under observation, casing the store, right? We
Yes.
don't have anything like that here, other than Mr. Bryant is walking on the street at 7:30 in the evening. And the police jump out. And he looks around. So surely the government is going to emphasize high crime area, lots of shootings in the recent weeks, and Officer Smith testified about that. And so, as Judge Wilkins' questions to defense counsel, appellant's counsel suggested, the police have to take care for their own safety. So they approach front and back, and they want to ask Bryant some questions. And so that's just life in the big city. No unconstitutional seizure. I mean, doesn't the government want to use all these factors and the shortness of time and the inherent danger of the situation to argue its case, as opposed to joining the appellant in trying to separate out all these incidents? I mean, but you seem to be joining appellant's tactic.
If I may, Judge Rogers, I certainly appreciate your question. I think in discussing the reasonable articulable suspicion factors, that was in response to what began as Judge Wilkins' hypothetical about whether, had Officer Smith been on the other side, or had, Mr. Bryant been on the other side of Officer Smith, whether that would have required suppression of the gun, which is why I, then turned to the government's reasonable articulable suspicion argument. But
I'm pushing you more on how is the court to view the legal standards in a changed environment, both legally and socially? Do we relax those standards? And that's what I hear being argued, not specifically, but implicitly.
I don't think that the government we're certainly not arguing that the court should relax the legal standards that it uses to evaluate Terry stops or other Fourth Amendment scenarios. What we're arguing in this case, a primary argument in this case, to come back to where I started, is that based on the district court's factual findings, based on this record, which we would argue are permissible findings, Mr. Bryant would have felt free to leave the encounter or to ignore the encounter with the officers at the moment where appellant's counsel has fixed the point of seizure. And we are arguing further that the point of seizure was later at 19:40:03, or when Officer Smith asked Mr. Bryant, what's that bulge right there? With the understanding that when he asked that question, he had seen a bulge that he, in his training and experience, believed was consistent with a firearm. And so we're saying that's the point of seizure. And
so to me, that is relaxing the standard because there's nothing specific. I thought that's what Judge Childs's questions were getting at. Nothing specific as to Bryant that's indicative of anything other than how a person innocent of any crime would react. Sees officers stop, park their cars, get out of the car. They're not running, but they're also not walking slowly. And they're headed toward him. I'm just trying to understand, both from the police point of view, that they're trying to provide for public safety, to protect their own safety, to protect citizens' safety. And this balance in this changed legal environment, given that communities can't regulate guns, and efforts to do so have been struck down repeatedly by the Supreme Court. So are we at a point where essentially, and the Supreme Court ultimately will tell us, but as a lower court, we're dealing with the standards that are out there. But I just wondered if the government had any view, and you reject that entirely, but you do move the point of seizure back. That's all. You require more. That's all I'm getting at. And the defendant, appellant, wants far less.
And I suppose if by require more, Your Honor, you are, I take your point there to be that it's that the government's position is that a seizure requires more than what happened by 1939.
Your argument. You're saying it wasn't until the officers said to Bryant, "What's that?" that he was seized. The appellant is arguing, oh no, he seized a lot earlier than that, when these officers are coming around the car and in front and in back of it.
Yes, and Your Honor, and the reason, I think there's sort of two
not having observed him specifically to do anything on illegal.
and I think
on the officer's experience, yeah.
I think that's part of why I keep coming back to the district court's factual finding about what a reasonable person would have seen and would have understood to be going on.
But the district court also puts as a factual finding that Bryant put himself in that position of being there. So is that not error if you look at the video cam to see officers at both sides? I mean, again.
Well, I think, I'm sorry, I didn't mean to interrupt.
No.
I think that what the district court meant by that point is that, Mr. Bryant moved away from the black car and walked up the sidewalk to behind the SUV, where he's sort of out of sight of the officers at that point, and then he stops. I don't think that the court was implying that he did anything other than he stood in a place where it was possible for police to come at him from different sides.
And the other thing I want to ask you about is, you all characterize this as a consensual encounter. What part of that is consensual by Mr. Bryant? By citing to cases saying that when there's a consensual encounter, and I'm assuming that when an officer, hey, do you mind if I ask you a couple of questions? Then that can be consensual if they say yes. But what part of this here under these facts is consensual?
Certainly, an officer can say, do you mind if I ask you a couple of questions? But this court has also said in United States versus Gross, that the question even, can I see your waistband? Mm-hmm. It does not rise to the level of a seizure.
But I'm asking you under these facts, and when you say, is that a gun? Is that consensual?
By that point, when Officer Smith has asked, what's that bulge right there? I mean, that's part of why we're saying that's a seizure. Before that, the question that was asked.
You don't have any guns on you. You're saying that that's consensual.
That's closer to the questioning in cases where this court has said that, based on the question, that it's not a seizure.
Okay, but I have a different question. I didn't say seizure. I said, is that a consensual?
Oh, a consent.
Because that's how it's being characterized.
Yes, and this is as we've been discussing all morning, it's a very fast-moving situation. So it's possible, certainly, that
I just want to know
In a
your,
different-
your scope of
No,
what people perceive as consensual encounter by the police. 'Cause I think that asking permission to ask a question is consensual, if you say yes.
I
But
think
asking the hard question, is that consensual?
under this court's case law, yes, I think that it is.
Okay, fair enough. And then you all indicated it was a citizen encounter. What do you mean by that?
The police are speaking with a person on, out in the community, I think is the way that I would.
But police
sort of
speaking to a person is not a police encounter?
Oh, I think that's just, the phraseology that, we've used in our briefs, and yes, it's from the perspective of the police. Certainly from the perspective of the citizen, if a citizen, it would be a police encounter, but the fact that it's a police encounter does not in and of itself make it a non-consensual encounter. And just to go back, what I was trying to respond to the court, it's possible that the Officer Smith could have asked, do you have any guns on you? Mr. Bryant could have said no, and then the officer never saw a bulge, and then everyone would have gone about their day or their evening in this case. And I think it's that crucial second or 2 seconds in between where it morphs from a consensual encounter to a seizure, because at the same time that Mr. Bryant is sort of he's aware now that there are officers on both sides of him. That's the same time that Officer Smith sees the bulge.
Okay, and one last question for you. Obviously, lower courts can opine on credibility, but you have here at least that investigation with respect to Officer Smith. Do you know what was before the district court in terms of him having this approach and him being under investigation? Do you know what the district court knew, or is that something that's kind of after the fact?
My understanding is that it's after the fact, just based on, but I can't speak to that definitively. I was not the district court AUSA on this case, and I don't have, the dates of when all of this was happening to mind. Certainly, I would expect that.
What was the date of the article in the Washington, in the record? We can look it up.
I believe, and I think it might even be in, if the court will just brief indulgence. At least, I don't know about it in the record per se, but I can point the court just now. I'm happy to follow up with a letter to the court if that would be useful, but would note that in Appellate's counsel's brief, they cite 2023 as the date of the article that, raises this issue for the court. So that's certainly
Well, the
after.
article was at least available publicly, published July 14th, 2023.
And yes, Your Honor, and the suppression hearing in this case took place on May 5th of 2021. So, I believe it did relate to alleged conduct that happened within the time frame that this case was presented, but that's not something that the district court took into account because it was not before the court, is my understanding.
What was not before the court?
The fact of the investigation that is reported in the article that we were just discussing.
Oh.
And I'm not sure that the investigation had even begun. But again, I'm speaking based on my post hoc sort of off the cuff understanding, because it's my understanding that was not before the court at the time of this hearing.
So,
But the government knew.
I'm not sure the answer to that. I wouldn't imagine that. I mean, certainly the government has obligations with respect to disclosures under various rules and case law. I really cannot speak to anything outside of the record of this case in terms of what was disclosed or what was known by the government. I honestly just do not know. But again, happy to follow up with the court in a letter if that would be useful.
So just to get down to what I would consider to be brass tacks here. the appellant's argument seems to be that at 19:40 and 0 seconds, when Officer Smith is stepping onto the sidewalk, that the seizure occurs, in that there's no reasonable articulable suspicion at that moment. Let's suppose the court agrees that there's no reasonable articulable suspicion at 19:40 and 0 seconds, and that the reasonable articulable suspicion doesn't arise until 3 seconds later, 19:40 and 3 seconds, when the officer seems to have clearly observed bulge because he asks a question about it. If we believe that the seizure, as appellant would have us argued, occurred at the 0 second mark at 19:40, why isn't this case exactly like my hypothetical where the alternative facts or alternative scenario where Bryant didn't stop at the white SUV, he kept walking. And so at 19:40 and 0 seconds, Officer Smith says to Bryant, who's walking away from him, stop and turn around. And he turns around, and at the 3 second mark, he sees the bulge and then grabs him. If we believe that there's no reasonable articulable suspicion at 19:40 in my hypothetical where Bryant kept walking instead of stopping at the SUV, we would suppress that weapon under our case law because there would have been a submission to a show of authority, so there would have been a seizure before there was reasonable articulable suspicion, and it wouldn't matter to us that he obtained reasonable articulable suspicion just 3 seconds later. Wouldn't matter to us. So on our facts here, if indeed he was, if the district court found or should have found that he was seized at 19:40 and 0 seconds, and if we agree that there's no reasonable articulable suspicion at that point because all he has said is, you don't have any guns on you, and he hasn't seen the bulge yet, then why should there be a different result here? Why wouldn't we suppress that weapon?
I mean, there needs to be reasonable articulable suspicion to support a seizure. That is the only thing I can think of in both scenarios, Your Honor, is that splicing what happened second by second in these encounters where they're fast moving and there are safety concerns for the officers and for the people around would, for lack of a better word, hamstring law enforcement. But aside from that practical consideration, it can, and without a reason to not exclude evidence that's obtained, certainly we don't have an intervening circumstance in this case, or under the hypothetical that the court has given. Without reasonable articulable suspicion, I think the cases are. This case would be harder than the hypothetical that the court gave about where there's very clearly the officer has said stop, and there's been a submission to that command to stop. But they are much closer than what we have here.
Any other questions, Judge Childs or Judge Rogers?
No.
No, thank you.
Thank you. Ms. Rowland, I believe you were out of time. We'll give you 2 minutes on rebuttal.
Thank you, Your
Thank you.
Honors.
Thank you. I just want to address a few points. One is that regarding this timing, what a reasonable person would have perceived when Smith came around the corner and questioned him really isn't linked to when Officer Smith gained reasonable suspicion. So, I mean, those are two different questions for the court. When was he seized? When was there reasonable suspicion? And the fact that there was very little time between them or a lot of time between them really isn't relevant.
Well, I don't see how you got an argument that he was seized before the 1940 and 0 second mark.
Oh, no.
Both because you didn't make that argument below.
Agreed.
And I don't think that.
Right. What I'm saying is at that moment, 1940-00, that's the moment that Mr. Bryant or a reasonable person in his circumstance would have perceived a show of authority. The fact that Officer Smith gained his reasonable suspicion 3 seconds later, 10 seconds later, 2 minutes later, it just isn't, the two things are not linked.
Well, they're linked if Smith observes because he steps onto the sidewalk and that enables him to observe Bryant.
I think,
And so I'm going to ask you the brass tacks question.
okay,
I look at page 18 of your brief, I think it is. Got a picture. Well, it's page 10 of your brief. You've got a screenshot of the second screenshot. It's 1939 and 59 seconds. Smith isn't on the sidewalk yet. It looks like he's a couple steps away from the sidewalk. So at best, he gets to the sidewalk at 0 seconds.
yes,
It's going to take him another second or so to get up onto the sidewalk to quote unquote block Mr. Bryant's egress. So here's my brass tacks question. If I believe that he's not really blocking him until at least the 1940 01 or 02 point, and at that point, he's seen the bulge, don't you lose? Because essentially the seizure is simultaneous with him obtaining reasonable articulable suspicion, because you concede that when he sees the bulge, he has reasonable articulable suspicion.
yes, he does. But they aren't simultaneous. There's enough time for Officer Smith to ask 2 questions and to get at least one answer.
Well, we know when the questions were asked because we can see that on the
Right.
camera.
Right.
And the
So,
third question is at 14:03.
right.
And
And the
the
first
district court
question-
finds that he's raising his hand between the 14:01 mark and the 14:03 mark, and you can see that in the camera. So he's raising his left hand as if to point towards the waistband.
Or to
So-
communicate, hold on here.
Well, maybe not, but the district court, we have to, under Ornelas from the Supreme Court, we have to give due weight to the inferences from the factual findings
Yes.
of the district court. I'm not sure what that means. It's not clear error, it's not abuse of discretion, it's due weight. But her inference from the fact of him raising his left hand is that he's fixated on his waistband. And that's what these officers are trained to do. The gun interdiction, where do people hide the guns? In their waistband. So that would be the first place he would look when he had an opportunity to. When he clears the SUV, he looks right at the waistband, raises his hand, and that's at like the 1 second mark. So he sees it then right as he is blocking the sidewalk.
Well,
So the two things happen at the same time, counsel.
Judge, they don't happen at the same time. His second question would not have been, did you step off? If he had seen a bulge. It was only after that question that he saw a bulge and then said, what's that? If he had seen a bulge, why would he go from, you don't have any guns, do you, to like, just step off? No, he would zero right in on that. What's that bulge? Let me see that bulge. So there was time between when Mr. Bryant was seized and when the officer believed that he saw a bulge, and which gave him reasonable suspicion. And the fact that the time is so short, I don't think really makes any difference. If the court finds that, 1 or 2 seconds or 3 or a short amount of time, 5 seconds, 10 seconds between seizure and reasonable suspicion doesn't matter because they're all very short, even 5 seconds is short, then
That's not what I'm saying. My hypothetical or what my question to you is if isn't it a fair inference from the facts that the officer sees the bulge?
it was simultaneous.
At the moment that the officer essentially completes stepping up onto the sidewalk.
That is not a reasonable inference from the evidence. And for one, the reason that I just gave, that he wouldn't have continued to question, he wouldn't have asked, oh, are you trying to evade the police, if he had seen a bulge? That doesn't matter anymore. Now we've got reasonable suspicion because I see a bulge.
You're acting as if like a long period of time took place.
Well, if
It's 3 seconds. It's don't have any guns on you, stepped off, what's that?
if he had perceived the bulge,
Literally about that quickly.
but if he had seen the bulge, he wouldn't have asked, stepped out. Why would he ask that question?
Okay, so.
He would have just
fair,
gone
fair,
straight to.
fair. At the moment he says stepped off, let's say he didn't.
He still doesn't.
He didn't see it. That's 1940 in 1 second.
And there's a seizure. There's a seizure. And then at 40 and 3 seconds, he gains reasonable suspicion. I mean, the fact that those are so close, that these are.
So we're going to, scrutinize this like, NFL instant replay or something by looking at the cameras, the different angles and taking it frame by frame.
Well,
And saying, at this frame he seized, and so he doesn't get reasonable suspicion till, the next frame afterwards.
Exactly. I mean, the reason that we have body-worn camera, one reason is so that we can see exactly the timeline, exactly when things are happening. And it's not outlandish at all for the court to, look at that.
Well,
Here he was seized and here.
The district court makes a finding. I guess what I'm getting at here is that if we were to give due weight to the inferences from the district court's factual findings, we review the factual findings for clear error. We give due weight to the inferences that the district court makes from the factual findings. Now we review de novo whether there was a seizure, in whether there was reasonable suspicion. But if the district court makes the finding based on the testimony, which we didn't see, and reviewing the body worn camera, et cetera, that really the blocking doesn't happen until the 1940 and 3-second mark. How do we overturn that?
Because the court can look at the video camera, the footage itself, and see what happened at 40 and 0 seconds.
How is that giving due
And-
weight to the district court's findings?
The district court, well, to the extent the district court found that he wasn't seized at 40 and 0 seconds, we're arguing that that's clear error. And whenever the bulge, Smith saw the bulge, it was after that. Whether it was 01, 02, 03, it was after that. And something happened in between that, which is he asked a completely unrelated question.
Okay. Judge Rogers, anything else? Judge Childs?
Thank you.
All right, we have your argument. We'll take the case under advisement.
Thank you.
Case number 23-1126. In re Western Coal Traffic League petitioner. Mr. Colasar for the petitioner, Mr. Quinn for the respondent.
Good morning, Mr. Colasar.
Good morning, Your Honor. May it please the court. Here this morning on behalf of the Western Coal Traffic League. In its opposition, the Surface Transportation Board contends that there is no basis for mandamus because what took place before the board, Revenue Adequacy 2014, the Ex parte 722 proceeding, was simply an informational docket. And the board uses that terminology repeatedly in its filing, namely informational docket. They seemingly try to avoid the use of the word proceeding. We don't believe that that labeling exercise is dispositive. Simply referring to the proceeding as informational, particularly in this situation where that labeling does not occur until years after the fact. We do not regard that as, again, as dispositive. We think that it was more important under the Administrative Procedure Act 555B and 555E is what the board said when it initiated 722 back in 2014 and how the board has conducted itself with respect to that proceeding in the intervening years.
So what authority is the board acting under when it opens this EP 722? What statute, what regulation is it relying upon to act there?
In terms of its authority to initiate any proceeding whatsoever.
Well, this particular proceeding that you are challenging, what authority was the board acting pursuant to? What statute, what rule?
I'm not able to quote you a specific one at this point, but it's enabling statute just generally in terms and its ability to conduct business.
Well, here's why I'm asking that question, because you rely on a case like the Fox television case.
Yes, Your Honor.
For why we have jurisdiction because the outcome of this proceeding would have some sort of legal consequence. And so that's why we would have jurisdiction. There, the statute was quite different because it required the FCC to act every 2 years.
Yes, Your Honor.
Here, the statute doesn't require the Surface Transportation Board to act, within any specific time frame.
Correct.
And then to the extent that someone is challenging rates, the relevant statute 10704B says the board may begin a proceeding under this section only on a complaint.
Yes, Your Honor.
And so it seems like this is a completely different type of statutory scheme in the sense that the board wasn't really like compelled by statute to do anything here. And yet you're telling us that somehow them not completing what they did has some sort of legal consequence. And I don't understand that if there's no statute that says they even had to do anything.
I understand your question, Your Honor. It is our view that having taken the step of initiating the proceeding, the board then triggered its responsibilities under the Administrative Procedure Act to conclude those in a reasonable time and to issue some decision explaining its reasoning.
So anytime an agency says, we're thinking about something and we're trying to figure out if it's a problem or what we need to do about it. So we want to just have an informational proceeding and gather information. Essentially, anytime an agency does that, even if they have no requirement to do that, once they do that, there's legal consequences that follow from their failure to act, because one thing that they could have done at the end of this informational proceeding was to say, okay, we're going to have a notice of proposed rulemaking. And the fact that they didn't do that is a legal consequence. So anytime an agency just has one of these informational proceedings, it's gives us jurisdiction to entertain a petition like yours.
That is not our position, Your Honor. Our position is that such events as you've described would be possible, but in order to fall into that category, it would have been necessary for the board to have, in its notice initiating that process, that informational docket, to have been far more explicit than was the case here. We believe that the court said in this instance it intended to address the issues discussed above. If I may, the board—
But there was no notice of any rulemaking or even any anticipated rulemaking in the notice, correct?
That's correct. It was not. Well, let me back off a little bit on that. It may have been part of the process of formulating rule, but it did not identify itself as being an advance notice of proposed rulemaking. It did not identify itself as being a notice of proposed rulemaking.
Could the league have filed a petition for proposed rulemaking some time ago?
Certainly, we
So
could
why are
have.
we on this procedural mechanism versus that?
I think there are a couple of reasons for that. One, timing. Here, April 2014, the board issues an ex parte proceeding and initiates an ex parte proceeding, and says, we're going to address this issue. We're going to invite comments from anybody who's interested to help us know what to do. So many, as you may have seen from the record, many different entities filed comments and made suggestions, and there were multiple different versions of suggestions as to how the revenue adequacy evaluation process and application process in rate cases should be undertaken. It's not clear to me at what point the league or others should have known, wait a minute, that was all a failure. The board decided not to do anything on that. Now file your petition for rulemaking. We've got to—
What's considered reasonable when the APA says that you should, any agency, when making any consideration, should do something in a timely and reasonable manner? What do you consider that to be based on case law?
Doesn't need to be weeks, doesn't need to be months, probably doesn't need to be a year. Maybe it could be a couple of years. We're approaching the 10-year anniversary of this notice. The board, in its opposition filing, lays out a test for how the public and the court should know whether something is an informational docket. And this is on pages 7 and 8 of their opposition filing. They say, based on a 2010 decision dismissing about a dozen cases simultaneously, you will know it's only an informational docket if, when the record closes, the case automatically discontinues. By implication, or by converse.
But in that notice, it doesn't say action will specifically be taken one way or the other.
Right, it says that it will just be over on its own. Here we have a situation where the record closes for the first time in August of 2015. By the beginning of 2016, the board has begun a now mandated process of reporting to Congress every quarter, and the total is now up to 34 times, where the board has told Congress that revenue adequacy remains a pending proceeding. It's one of the significant proceedings that's going on. So we're seeing both sides here. On the one hand, we were supposed to know that it ended automatically. And conversely, the board is telling Congress, no, we're still working on that. And in many of those quarterly notices, the board identified specific dates as to which the next decision would come out. So it doesn't look like the 25th anniversary of the Staggers Act to review and look ahead, which was one of those dozen proceedings that the board dismissed back on whatever date it was in 2010. This looks like a much more consequential case with significant implications for rate cases where many parties have participated, and the board is telling Congress this is ongoing. It doesn't look informational.
Maybe what if we agree with all of that, but we feel that, well, you've got alternative grounds for relief, which is to just file your petition for rulemaking. And then if they don't do anything with respect to that, then you can clearly get relief from the courts, because that's clearly reviewable. So you have, you're not supposed to get review in the nature of mandamus unless there's like no other alternative grounds for relief. So why isn't that a problem for you?
It is correct. We could have filed a petition for rulemaking at any point in time. But the second part, the timing issue I started to explain earlier in response to Judge Child's question. The second factor that I believe is responsive to your question is a more substantive one. The board had in hand many different proposals for how revenue adequacy ought to work. At this point now, do we go back in and file a new one? Do we file what we filed before? Even if we file exactly the same thing in 2024, do we then wait a year or two to see what happens on that one? We have what, for lack of a more dignified expression, a whack-a-mole problem. Is each individual entity supposed to file its own petition for rulemaking, and the board 2 years later can smack each one down, and then we'll go another couple of years or a few years of individually rejecting all that has been pending for 10 years.
But you just conceded that you have an alternative remedy with respect to the proposed rulemaking. So even though you feel like those options are not practical, does that still hinder our ability to grant you relief?
I would say no in this situation by virtue of the history here. By virtue of the fact that the board asked parties to come in, told parties it intended to address things. I might add that.
So does that mean you're looking at a failure to act kind of brings you here?
A failure to act, I'm sorry, a failure to act in response to board action. We're not the ones who had the idea that the board ought to initiate a proceeding about revenue adequacy. It's not that we didn't come at this out of the blue. The board initiated this proceeding, said, by the way, in October of 2016 in an ex parte 664 decision that the board quotes in its brief, that it will address issues relating to revenue adequacy in a subsequent decision in docket number EP 722, 2.5 years after first initiating the proceeding and after the record first closes. So to try to, again, answer your questions about whether we have an available remedy, it is true we could file. Whether that is necessarily dispositive here, we would say no. Again, in light of what the board has done and how it has conducted itself.
So in your petition, go
board's-
ahead, Judge Rogers.
Thank you. The board's response indicates, do you not agree, that it has not been sitting on its hands? It has taken other steps, not what you want, or not completely what you want, but it's not as though it issued that request and then has done nothing.
Your Honor, we would certainly agree that that's what the board says in its filing.
Well, you
We do-
can't deny that, can you? You certainly haven't denied it. That they do. There's no challenge to the fact the board took these other actions. Isn't that correct?
I'll try to answer, but perhaps I'm not sure I understand exactly what you mean by the other actions. As I read their filing, they said that they have been engaged in many other proceedings. So yes, there have been other proceedings going on, but in many cases, those are over. They ended years ago, or they took place years after the 2014. It's not an agency that's so busy at any given time that it can't resolve the revenue adequacy case.
Well, that's not their representation to the court, but even if you're correct, why hasn't one of your members filed the petition for rulemaking? That's what I'm not clear on. You say, what, it's burdensome because you'd have to repeat filings?
We would have characterized it not so much as burdensome, but as, well, burdensome perhaps in the sense of additional delay, but practically unnecessary given what's already pending. There have been
You just file a petition, and I don't know the board rules whether or not
we're
It-
entitled to file one. I'm sorry.
it forbids incorporation by reference. But even if their rules did, you could just file those documents. I thought you were going to argue, this is a very burdensome proceeding, a rulemaking, it's costly, it's timely, but that's not your argument. Apparently, you just don't want to file a rule.
I would say time consuming in the sense that we could file a petition. There would be some additional expense associated with drafting the petition, some additional burden associated with filing it, but then we would run into the delay problem. Essentially, it starts the clock over again in terms of what the board is allowed to do.
Well, if you filed on, let's see, April 1, and the board did nothing for a year, given what the board has told Congress and what it says it's going to do now and how it wants to set up its docket, and its view that your position oversimplifies the balancing of interests that the board must undertake, then aren't you in a better legal situation than you are now, where you're asking for mandamus, which I think, anyway, you know what mandamus is. You know what the courts have said about it.
Yes, Your Honor. Are we in a better legal position? I suppose that's one possible interpretation. We could file a petition for rulemaking. The board could initiate a rulemaking proceeding, receive comments, and then sit on those comments for an undetermined period of time. We don't understand that the board is contending that it has so many more important matters that it can't get to revenue adequacy. We understand the board to be saying, much like what Judge Wilkins had identified in his dissent 3 years ago in the WCTL SDB case, that it's easier to, I apologize, I'm not quoting exactly, to say that a matter isn't important by pretending it wasn't important to begin with. This, in 2014, was billed as being something terribly important. Now we're being told it was just informational, it doesn't matter. Yes, we could file a petition for rulemaking. Would we be in any different situation 2 or 3 years from now if we were forced to come back to the court?
To follow up on Judge Rogers' question, you asked for 2 different forms of relief in your petition, one or the other. The first one that you asked for, which is your kind of your first choice, your preference, is that we order the Surface Transportation Board to publish a notice of proposed rulemaking within 90 days and take final action on that notice within 1 year or some other reasonable period of time. What would that notice of proposed rulemaking say? It would have to propose a specific rule, right?
Yes, Your Honor.
So what you are asking for us to do by way of mandamus is for them for us to order them to decide what rule they want to propose and then publish that as a notice, as a proposed rule, and go through this. Whereas you haven't even filed a petition to ask them to institute a rulemaking. Because if you filed the petition, what would come out of that would them say, yes, we're going to institute a rulemaking, or no, we're not. And then you could get review of that. And you would have to establish whether it was arbitrary and capricious for them to say, no, we're not going to institute a rulemaking. You're trying to skip over that altogether and have us, by mandamus, order them to start a rulemaking. Not, is it arbitrary and capricious for them to institute a rulemaking or not? No, we're going to go straight to ordering them to instituting a proposed rulemaking. How do we get there? Isn't that a gargantuan leap?
We wouldn't ask you to dictate the particular rule that they would propose, but we don't believe it's a gargantuan leap, by virtue of the fact that they've been sitting on proposals for 10 years.
Well, what I'm saying, it's a gargantuan leap in the sense that what you could do is ask them to institute a rulemaking, and you could say the proposed rule should be X. We want you to institute a rulemaking and say, we agree with the Western Traffic League, and we are proposing a new rule of X based on their recommendation. And then if they said, no, we're going to do a proposed rule of Y, then you could seek review of that. And then we would be reviewing, well, should they have chosen Y over X? And was that arbitrary and capricious or whatever? Or they could say, no, we don't think we need any new rule. We think everything is just fine now. And we would be reviewing that. But you are trying to tell us now by way of mandamus, no, we're not going to do any of those things. We're going to tell them that they have to propose some sort of a rule. You're saying that we don't have to order them to propose the rule you want them to, but they have to figure out some new rule to propose. And within 90 days, propose that. What's the authority for us ever having done anything like that?
Well, in terms of an exact precedent. I don't have one for you. We don't regard the situation as being one that we've seen happen before.
Does the court just have inherent authority to do that?
We would say that you have your inherent authority under the track line precedent and under the Administrative Procedure Act to compel the agency to complete what it started on its own initiative, and complete it pursuant to the court's instruction to protect your future jurisdiction.
So your second alternative form of relief is for us to order the Surface Transportation Board to serve a final decision in EP 722, the Revenue Adequacy 2014 proceeding, or whatever we want to call it, within 90 days, explaining why it is discontinuing the proceeding. And I started this by asking you, like, what statute even says that they have to have initiated the proceeding in the first place? And you couldn't tell me one. So how is there some sort of clear and indisputable right if there's no statute that required them to even institute it? Where's the clear and indisputable kind of authority that they have to discontinue it in a certain way or in a certain time frame or with certain reasons?
We would say 5 USC 555B and E.
And 555E talks in terms of proceedings, and the statute defines proceedings. And this isn't any of the three things that the statute calls a proceeding, right?
We would not agree with that, Your Honor. We would say that the definitions for the APA in 5 USC 551 are drawn very broadly. And that agency proceeding means an agency process as defined in paragraphs 5, 7, and 9. Rulemaking under 5 is an agency process for formulating, amending, or repealing a rule. That was the basis for my answer earlier to Judge Childs on this, not saying that it's a notice of proposed rulemaking, but potentially falling within the scope of the process for formulating a rule. And then on adjudication, the definition of an adjudication links to an order, and an order is very broad. We see it as applying to anything other than rulemaking, so that it's fairly comprehensive. When we look through those, we see the APA as being fairly comprehensive in terms of its agency proceeding definition, arising by virtue of the board's action in what it did in 2014 and saying it would address the matter.
So if an agency says, you know, there's kind of new technology or new circumstance that has arisen that we have heard about, we don't have any rules that cover this circumstance, we want to gather information to determine whether, you know, that should be a concern to us, whether we should, you know, have a rule covering this new circumstance. And so they open up this informational proceeding. Maybe they use the word proceeding. And then they conclude it without taking any action. You're saying that the minute that they kind of use the words, well, we're trying to figure out whether there should be a rule, that makes it a rulemaking proceeding under the statute?
No, Your Honor. We would say that the board statement that it would address the issues, that is, in our mind, what separates this from a hypothetical like what you're describing, where the board is far more explicit and simply says, here's a new area. We need to understand this area better. Please let us know what you think. We don't anticipate issuing any decision at the end of it. We just want to better educate ourselves. we think that would be something that would that would be a very different sort of situation than what we see here in terms of the application of the APA.
If Judge Childs and Judge Rogers don't have any further questions, why don't you take a minute to, cover anything else that we haven't asked you about?
Let's see. Or that is what I had intended to cover.
All right, so we'll give you some time on rebuttal.
Thank you, Your Honor.
We'll hear from Mr. Quinn.
May it please the court, Tom Quinn for the Surface Transportation Board. The league is asking for extraordinary relief here, but they have not met the high burden required for a mandamus. They have not shown a clear duty to act because the board statutes did not require a rulemaking, as they concede here today, and the board never said that it was initiating one. And they have adequate alternative remedies. They can petition for rulemaking, as the league has done many times before, and as they concede today that they still could do, and their members can file rate cases, and the board must give them full consideration. Instead, they are trying to undercut the board by turning its informational docket into a binding rulemaking proceeding.
Can you blame them after this long on not responding to the various comments and the issues that they have put in front of you for quite some time?
We understand that they want an affirmative determination, particularly on their conception of what the rule changes should be or how to implement the constraint. And they can get that answer by simply coming to the board and filing a petition for rulemaking with their construction that they want. But there was no underlying duty for the board here to engage in a rulemaking. They rely entirely on 555B and E of the APA, but importantly, those provisions govern processes that an agency must follow once it has an underlying duty to act in the first place. And it's that predicate underlying duty that's missing here in this informational docket. And I think comparing and contrasting the cases, the Fox Television's case that Judge Wilkins mentioned, the statute there is what's important. And the statute there said every 2 years, they must review every one of their rules, and they must either make an affirmative determination to keep it or to start a rulemaking to repeal or modify it. And that's in stark contrast with the Center for Biological Diversity v. Zinke case that we cite in our brief, where the court held that there's no free-floating duty for an agency to complete. There it was, they filed a notice, they had a hearing on important issues arising out of the Deepwater Horizon oil spill and disaster. And even there, the court said, because there's no underlying legal or legislative duty, there's no requirement for action that the court can enforce. And
What about the APA's general rule about once agencies take on issues that they should, within a reasonable period of time, address the issue?
Yeah, I think that's the 555B argument, Judge Childs, and their cases demonstrate, all 4 of the cases that they cite, there was some underlying predicate that legally required action by the agency. In the Cutler case, there was a new statute that Congress had passed that the agency had to respond to. In the INRI International Chemicals Workers Union case, there was an NPRM issued by the agency. In the Octor case, I think it's PCHRG, the Octor, there was an ANPRM. And in the INRI American Rivers and Idaho Rivers case, there was a petition for rulemaking under the agency's regulations. And in all of those circumstances, the board would agree that there is an obligation to act and to come to a final conclusion. But here, all the board did was start an informational docket and set out to gather more information from its constituents. And that's what they did here. Then
They're saying that this is essentially a bait and switch because you said we're going to address issues and take all this information in, you close it, then you reopen it, then you're telling Congress, I'm saying you, but your client is telling Congress, oh, we're still working on this. I mean, you can't have it both ways, right?
I would agree, Your Honor. And I think that if you look at the notice and you look at the reports to Congress, there's no two ways of interpreting it. What we said in the notice was that we were going to have a public forum to discuss these issues with a view to what, if any, changes the board can and should consider.
Didn't you
Yes,
say
we said,
address?
yes,
Did the
yes.
board say address issue?
They did, Your Honor. They said it in multiple places in the notice. They said that they were going to address these issues. They also said they were going to explore these issues. And they said, I believe on the first page of the notice, that they were going to have a public hearing to address these issues. And in that context, I think it was quite clear that address meant discuss and explore. Nowhere in that notice did we say this will be followed by a rulemaking. Sometimes
Doesn't
the
this
agency might do that.
exploratory inquiry that doesn't seem to have an end potentially have a chilling effect on your stakeholders in terms of them actually being willing to make comments that should help you in furthering any proposed rulemaking?
I'm not sure what the chilling effect would be. I think it would actually be of immense benefit to have this kind of proceeding to stakeholders, because then they have an opportunity to air in front of the board our proposal, and others have that same opportunity, the
Referring back
railroad.
to, Judge Wilkins's
Yeah.
bait and switch piece, where you indicate you'll start that process, then you close it, and then nothing happens. And then you start it again, and then everybody gets excited, you start putting comments out there, and then you stop it again, close the record, and then nothing happens.
Yeah,
And so on and so on.
a few comments on that. I think that the conception of calling it a bait and switch is really belied by the league's own comments in what they submitted to the board in response to this notice, and in other shippers' comments where they noted that there was no proposal for action here. So that the league and others were providing general comments for the board to consider. I think this is a great opportunity for the league and shippers and for the railroads, who have the opposite perspective on a lot of these issues, to air what they think is an appropriate action for the board and to have public discussion in a way that isn't in a binding rulemaking proceeding. It provides greater latitude to the constituents to explore these issues. And then briefly on the congressional reports that Your Honor raised. Their argument seems to be that the fact that these are included in the congressional reports at all is misleading. But if you look at the reports themselves, they are abundantly clear in the updates to Congress. What is happening? They say right at the top that they are pre-rule. They provide the date that the notice was initiated. It describes actions that have happened through the years on this docket, including the rate reform task force that was started, when their final report was issued, when there was a hearing held on these issues. And these are all very much straightforward, honest. There's no contention that there's anything misleading in these reports. It's just the fact that they still exist.
Contention that the reports are written in a way that suggests that the proceeding is ongoing. It's not really closed.
The position is that the docket, the number 722 docket itself, is still open, but the record is closed in the proceeding. And it says the date that the record was closed, and it apprises Congress of new things that have happened related to the same substance, the revenue adequacy issues since the docket closed. And the most significant one of those being that the certain railroad interests filed a petition for rulemaking on the revenue adequacy methodology, and the board read that petition, instituted a proceeding based on that petition. That's the same route that the league could follow here.
So, but I guess the question is, if the representation that is made to Congress is that the docket is open, the record is closed, but the docket is open.
Yes,
Is that accurate?
yes.
So while this docket is open, then the agency hasn't taken kind of final action. We can debate whether it's final action, final agency action that has a specific meaning in administrative law. But as of now, the agency hasn't even taken final action because the docket's open.
That's right, Your Honor. There hasn't been a determination, a final action, as you said. The docket is still open.
And all they're saying is, well, at least give us a final action. Close the docket. Because how are we to know, we could we could be kind of wasting our time filing a petition for rulemaking because you could close the docket by tomorrow, your client could, by saying, we're closing this docket because we're going to institute proposed rulemaking in 90 days.
They could, Your Honor. I think a couple points on that is one, that the act of whether they want to keep the docket open or closed goes to their wide latitude and discretion in managing their docket. That's a principle that this court has affirmed many times, including recently, just last month, dismissing a different petition by the league related to a proceeding on cost of capital in front of the board, where their petition was denied because they filed a petition in the wrong docket. It was case 12. I believe I have the citation for that case. Case number 23-1272. But in any event, the board has not issued a formal closure of the docket because these matters have not been finally decided. And that's been consistent practice in this docket. It opened the docket to initially
have not been finally decided. That's what I'm not clear on. In other words, keeping the docket alive, as it were, is a wonderful way for the board to say, if you want any action, file a petition for rulemaking.
Yes, Your Honor, we believe that that would be the right course of action if any of the parties want to have the board decide affirmatively on one perspective, one construction of revenue adequacy, the methodology, or based on the constraint that they should file a petition for rulemaking. Because this board made clear from the outset that this was purely an informational docket. The league and other constituents knew that. They said so in their comments to the board. There was no bait and switch whatsoever. This was meant to be a docket to discuss. And the record closed initially, and then the board did reopen the docket several years later after they had the rate reform task force do their report and had another hearing in the same docket to explore the issues further and then close the docket again. So I think that all goes.
Let me just be clear. If a petition for a rulemaking was filed, why couldn't the board simply say, well, we're still exploring this issue. We don't know exactly what kind of rate reform we want to adopt, both procedurally and substantively. In other words, the board puts itself in a position where it looks responsible, but in terms of the people or the entities regulated, there is no way to get a decision.
We would disagree with that, Judge Rogers, because they will get a decision. The board is required to give a decision on that petition. And we would say, too, that the answer to that decision could be, we do not want to institute a proceeding here. We have other competing priorities. We have limited resources, or we do not think your evidence is compelling. The agency has that entire breadth of discretion in how it wants to resolve.
So the question is, it puts out this information, or it opens this informational docket. And let's just hypothetically say all the significantly regulated parties and the small entities make a very conscientious effort, spend a lot of money, and file proposals. And it's clear that they're not all in harmony. And the board has to make some policy decisions, as well as decide what is the appropriate balance of interests. So the question in a way is, look, we've done the homework for the board. And of course, the board can do some more homework. But board, tell us what you're proposing. And then we can provide additional directed comment. In other words, we haven't wasted the last, I don't know, almost 20 years trying to deal with the board on an informational track, because it's just clear that the board has to make some decisions here. And anyone who files a petition for rulemaking could be wasting its time, and not just for the procedural reasons we were discussing earlier, but on substantive grounds. It says, do rulemaking A. And the board says, well, no, we have all these comments that say there's something wrong with rulemaking A. So then somebody files for rulemaking B, and we just keep going, and there's never any decision.
Understandable, Judge Rogers. I think the answer to that is that the board would have to be put on the record in response to a petition for rulemaking with its decision about what next step to take. And if that includes the denial of the petition, then they have to have reasons that are subject to judicial review for doing that. But that's not the question that we're faced here with on mandamus. It's whether there is an underlying legal duty that they must do that in this docket. And although the board certainly must answer questions and take a position on a revenue adequacy petition that's filed appropriately under the board's rules, which the league has done many times before, which the railroad interests did on exactly the revenue adequacy methodology that's being discussed here, then the board will go on the record and issue a final determination there that would be reviewable.
What is the meaning of the board discontinuing an informational docket? And is that the same as closing the docket?
Pertaining to the prior precedents that the board has entertained, my understanding from those prior precedents is that would have been the determination of the docket, in not talking about the 722 proceeding, that it would have been the conclusion of the proceeding when the record closed in those prior dockets. But in this one, the record itself is closed, but the docket has not been closed.
Well, yeah, I'm talking about back in 2012, when the Surface Transportation Board was addressing an information gathering proceeding, and they said, in the future, should the board hold similar informational hearings, the proceeding will be deemed automatically discontinued once the record closes, unless the board announces otherwise prior to the close of the record. So here the board didn't announce for this revenue adequacy information gathering exercise.
Right.
The board didn't make any advance announcement otherwise, so shouldn't the parties have followed what the board said earlier, meaning that when the record closed, the proceeding was deemed automatically discontinued? And you're telling me that discontinued is the same thing as closing the docket?
Are you
telling
believe
me
that's
that
right?
Discontinued is the same thing as closing the docket?
I do not have that's my understanding, but I don't have a firm answer on that, Judge Wilkins. I believe that's what happened in those prior cases. That's my understanding of what happened in those prior cases. But in this case,
So
yes.
why shouldn't we as a court, the regulated parties and the public, everyone else, then believe that when the record closed here, you discontinued the proceedings, and the same as you said earlier, that meant that this docket is closed. But you're standing here telling me the docket's not closed, the docket's still open.
Yes, I understand, Judge Wilkins, that there does seem to be a disconnect between that ministerial treatment of the docket in those prior proceedings and this. My understanding is that's the board's practice, is that they are kept open, or excuse me, that they are closed. When the record closed, they are discontinued. That's what that prior opinion said. In this case, the record was closed, but the docket number itself, I believe, is open, and that's why it continues to be reported in those congressional reports. But I think what's clear is that we state that the record is closed and that the parties know the record is closed and that there's no further action on this docket that's anticipated or that the board has announced. And so for the parties to know once the record closed, that their time would be right to file a petition for rulemaking if they want a rulemaking on these topics, which is precisely what the railroads did and what the league could do in this situation as well. And on their remedies, they have filed many petitions for rulemaking before. The board is required to respond to them. They could do the same in this case. And moreover, their members could file rate cases. Their concern ultimately is that they want to pay lower rates. And the way that that would happen would be, presuming they meet all the statutory criteria to bring a rate case, it would be through a rate case. Their impediment before they had stated was that under the annual determinations, the railroads had been found to be not revenue adequate, but for the better part of a decade, most of the Class I railroads have been found revenue adequate under the yearly determinations. And although the yearly determinations are certainly not outcome determinative in a rate case proceeding, they would not serve as the same impediment, and they could file those rate cases at any time. So, unless there are any further questions.
Judge Rogers? Judge Childs?
Nothing here, thank you.
All right, thank you.
Thank you.
All right, Mr. Colzar, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. The discussion about discontinuing the docket automatically, we think is very important. The board has told us in its filing that in informational dockets, the cases discontinue automatically. In the present case, the case did not discontinue automatically. And we know that because the record closed in August of 2015. And in the first months of 2016, the board told the United States Congress on a quarterly basis that the case was pending. A fair interpretation of those facts is that Ex parte 722 was not one of those lesser administrative, I beg your pardon, I don't remember the exact term that was used, menial dockets where the board simply wished to educate itself. A few other points. In re tenant, which we cited, this court's decision from 2004, talks about the court having future jurisdiction once there has been a proceeding of some kind instituted before an agency or court that might lead to an appeal. It makes sense to speak of the matter as being within our appellate jurisdiction. We think there has been a proceeding of some kind pending at the board. And we also are of the view that there is a tension between what the board has been telling Congress in each of its quarterly reports and what the board's opposition filing looks like in the present case. I don't have a specific sentence to quote to you right now, but my reading of the opposition was that it suggested that matters were concluded. It was not a priority item. The board has moved on to more important issues, and that we should not be anticipating a decision in Ex parte 722 in the near future. That's all that I have, unless there are questions.
All right. Seeing no further questions, we'll take the matter under advisement. Thank you.
Stand, please. This honorable court now stands adjourned until Thursday, March 21st at 9:30 a.m.